This is the House Judiciary Committee. It is a day, what, the 11th? 12th, okay, of March 2025. We have a number of bills in front of us today, and so I don't have a list, but I'm going to go off the folders that are in front of me, and there's the list. Let's go to House Bill 5, Delegate Wilson. Bill on child pornography, except there is an amendment. There's an amendment, 373329. Does everybody see the amendments? It makes some of the technical changes that came up in the hearing so very long ago, I think, and addresses some of those changes. Am I right about that,
Yes,
Claire?
it just changes the term child pornography to child sex abuse material.
It changes child pornography to child sexual abuse material. Can I have a motion on the amendment?
Move the amendment.
There's a motion for the amendment. Is there a second? Second. All right. We are on the amendment. Are there any questions about the amendment? All right. Seeing none, all in favor of the amendment, please raise your hands. Anybody opposed to the amendment? The amendment's adopted. We're on the bill as amended.
Move the bill.
There's a motion for a favorable on the bill. Is there second? There is. All right. Right, so on the bill as amended, Delegate Arikan.
Could Claire just tell us what the bill now does?
It's the same thing, except they just changed child pornography to child sexual abuse material. But Claire?
The original thing that the bill did was specify that for purposes of the prohibition against distribution of child pornography, or just possession of child pornography, a computer-generated image includes images created through the use of artificial intelligence software. And the amendment substitutes the term child sexual abuse material for child pornography wherever it is throughout the code.
Further questions about the bill? Seeing none, we'll vote it. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield? Yes. Yes. Cardin? Yes. Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Yes. Simmons? Yes. Yes. Boucher? Yes. Yes. Phillips? Yes. Yes. Stinnett? Yes. Yes. Congolo? Yes. Arikan? We're off?
Are we good now?
Are we good?
All right, for the record, every member of the committee so far for Bartlett, Valentine, Crutchfield, Cardin, Tomlinson, Embry, Pasteur, Tolles, Schmidt, Simmons, Boucher, Phillips, Stinnett, and Congolo, and Arikan have voted aye. Taylor? Aye. Simpson? Aye. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams?
Yes, and add.
Yeah, yes, and an add. Okay, who's adding? Cardin, Simmons, Pasteur, Schmidt, Phillips, Stinnett, Congolo, Arikan, Simpson, Grammer, Sample Hughes, Conaway, and Kaufman?
Yes.
And Taylor. All right. Okay.
Is sexual abuse material a term of art?
It's the term of art that is now being used because that's my understanding. Yes, it's become a term of art in this area.
More power to
Yes, more power to her.
Thank you.
Thank you. Delegate Addison's bill, House Bill 21. We've spotted a mistake, I think, in the bill, so I need to talk to subcommittee chair about that, so we're going to hold that one today. House Bill 74 now with Delegate Foley. Delegate Foley's bill does not have an amendment. Did this go through the subcommittee? All right. It does have an amendment. I'm sorry, 873322. All right. Do you want to describe what the amendment does, Subcommittee Chair?
Deleted.
Delegate Cardin.
That's not the right one. Give me 1 second to pull up. Yeah, this is it. Okay. The amendment, let me get to 21. Here we go. The amendment,
It allows, it looks like, for the advertisement to be distributed through a print and a digital format as opposed to or, is that right?
yes, we changed one where we changed the or to an and. It clarifies that if there is print, that it will be used print, and they can also use digital, so they can create a system. But if there is no print, then it can automatically go to the digital system.
And so I think it addresses an issue that was an issue in Dorchester County where they were one way or the other, and they needed to have that flexibility too. So this just gives other counties across the state. And so as such, looking at Delegate Sample Hughes, that part, the Dorchester County specific part of the law is getting taken out because we're all going to be, we're all in the same way then. All right, on the amendments, let's get a motion on the amendment, and then I'll take questions. There's a motion for the amendment and a second. Delegate Tolles on the amendment.
No, I was just, let me back up. I was wondering why we held HB 21. I just wanted to know.
Okay, I'm on House Bill 74
I know,
now,
I
so
didn't-
I'm going to deal with that.
Okay.
Are there questions on the amendment? All right, seeing none, thank you very much. All in favor of the amendment? Yes, Delegate, were you raising your hand to raise your hand? All in favor of the amendment, raise your hands. And anyone opposed? All right, the amendment's adopted unanimously. We're on the bill as amended. There's a motion for a favorable and a second. Any further questions on House Bill 74? Delegate Tomlinson.
Bless you. Can someone just explain what the bill, exactly what it's doing again?
Delegate Cardin, do you want to, or should?
Sure. The bill, it really didn't change, the amendment didn't really change what the bill did. Let me just, the bill gives some flexibility to people who are required to publish by Maryland law. There are certain requirements for publications. And there was a very strict way of having to do it. And this allows for publications to be either done by publishing and also with amendment, through a digital format. And that it also allows that if there is no print publication in the jurisdiction that meets the qualifications, that there's an exception that you can go just to the digital format, and it allows for that as well. Is that pretty close? Because as I'm preparing for the floor? Okay.
Questions, any more questions? All right, seeing none, we'll take the vote. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield? Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes, and an add. Phillips? Stinnett? Yes, and an add. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes, and an add. Kaufman?
Just plain yes.
Yes, and Williams?
Yes, it's plain yes.
All right. It's House Bill 74. Let's go to House Bill 246, which is an administration bill.
Move favorable.
There's a motion, there is an amendment. 903327, this went to the subcommittee, if I'm not mistaken. Delegate Crutchfield, this went to the subcommittee? I'm sorry. 246? Yes, it did. Okay, can you talk about the amendments to 246, please?
I can do that.
So the amendment is really one from the Emergency Medical Services System where they're requesting that the date be changed and also just adding in that the reporting that's under the bill can be done by the statewide hotline. And so they wanted to do this because they want to prepare for training, because they are under the bill as a provider that will be allowed to give disclosure and other relevant information regarding people that may be under the Adult Protective Services, may be reported and under the Adult Protective Services.
Okay. There's a motion and a second on the amendment. Are there any questions about the amendment? Seeing none, all in favor of the amendment, please raise your hands. Anybody opposed? Amendment's adopted unanimously. We're on the bill as amended. There's a motion on the bill as amended. Is there a second? There is. Any further discussion on the bill as amended? All right, the Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt?
Yes.
Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman?
Yes.
Yes. Williams? Yes. Right? 246 is adopted. All right. Now, House Bill 293. So look at Pippi's bill has an amendment. 363525. It's a motion on the amendment as second. The amendment adds language to two parts of the bill. In one, the first of the two amendments, it says, if the child victim testifies by closed circuit television, the testimony shall be given within the courthouse in a setting that the court finds will reasonably mitigate the likelihood that the child victim will suffer emotional distress. And then, again, this is allowing for child victims for there to be more flexibility in entering the testimony of child victims. In the second of the two amendments, the defendant or child respondent shall have a means of privately communicating orally in real time with the attorney for the defendant or child respondent who is in the room where the child victim is testifying. In other words, they have to have the ability to speak to each other just as if they were sitting at the table or sitting at the courtroom. They would have the ability to talk to each other. The difference is the child in some of these cases is going to be in a separate room where they would have to make those arrangements. The Vice Chair.
Mr. Chair, I just wanted to double check to see, is this amendment conforming the bill to the Senate?
It does. It conforms the bill to the Senate bill.
Thank you.
All right. Are there any questions about the amendment? It is in fact a conforming amendment. All right. There was a motion and a second, I think, on the amendment. Can I have a motion on the amendment?
Move the amendment.
There's a motion and a second on the amendment. And all in favor of the amendment, please raise your hands. Is there anybody opposed? All right, the amendment's adopted. Are there any, we're on the bill as amended.
Move the bill as amended.
Motion on the bill as amended, and second. Is there any further discussion on the bill? Seeing none on House Bill 293. The Vice Chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt?
Yes, Ed?
Yes, and an add. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes, and an add. Congolo? Yes. Erican? Yes, and an add. Taylor? Yes, and an add. Simpson? She's already on it. Grammer? Yes, and an add. Sample Hughes? Yes, and an add. Moon? Yes. Conaway? Yes and an add. Kaufman?
Yes and that.
Yes and an add. Williams?
Yes.
Yes. Phillips is adding. Pasteur is adding. Simmons is adding. Congolo is adding. All right. That's here. That's fine. Okay. House Bill 302 is Delegate Moon's bill. Delegate Moon, there are no amendments to 302.
Move the bill.
There's a motion on the bill. Is there a second?
Second.
All right. Delegate Moon, do you want to tell the committee what the bill does?
This is a tinier commissioner charging reform bill, and it adds the people who do elder abuse and child abuse investigations into a list of professions where a state's attorney needs to review a commissioner charge. It currently covers law enforcement, emergency services personnel, educator, and yep.
So this would add an adult protective services worker, a child welfare caseworker as well, to the list of people that goes directly to the state's attorney, correct?
Correct.
It goes directly to the state's attorney. Are there questions? We have a motion on the bill and a second. Are there further questions on the bill? Delegate Valentine.
Thank you, Mr. Chair. And I'm just curious as to the need for this. I brought this up in the day of the committee. I think when I was asking Ms. Feinstein about this, I actually asked her if this was a statewide problem. And she did get back to me through the MSA, Maryland States Attorneys Association, and said that with her colleagues, she didn't find this anywhere else across the state. It was specific to a specific jurisdiction. And that I was just kind of wondering if that was maybe a problem with that agency in that particular county, instead of a carve out just for one particular jurisdiction. So I try to kind of question the reasoning for it, I guess is what I'm getting at.
This was a by request bill from my county in response to a real case where someone did go through this and was not able to avail themselves of a government attorney in any way. So that is where this came from. It's an interesting question. I mean, I had predicted that if we do this and adopt this policy, we would surely see more professions asking to be added in here. But I honestly do think that as those cases come up, they deserve to be in here. You know, because again, on the other bill that we're looking at, HB 21, we're making other substantial reforms to the commissioner charging process. So,
Not knowing the final product. 21, will any of that product maybe eliminate the concern for this particular bill, to your knowledge?
Not quite, because this, you know, like there are some who would want to do this process for everybody. But doing it for everybody is what took us a long time to work through to get to just a narrow solution, you know. But people who are at work and getting hit with these retaliatory, people who are at work and have the power to make an adverse decision, you know, get them jailed, fined, arrested, whatever, their children taken away. These are the people that in various respects now we have body cams for them on a different bill, and here they're asking to be shielded from these kinds of frivolous criminal complaints. Elsewhere, we've seen people ask for felony charges to be brought against, you know, people to protect them. So, you know, this won't be the last we hear of bills like this.
I'm sure it will not. Thank you, Mr. Chair.
Delegate Erican.
Okay, it would be, there's a lot of people on the committee now that weren't here for what happened in Montgomery County, and I know it's kind of a touchy subject, but like, we might need a little brief overview of what happened with the Child Advocacy Center there, and just an explanation of what occurred, which is, I'm assuming, the situation that it has been bred from. Is that what we're, just give, he's like, I don't want to talk about that. Is that it, or is this a different case? Oh, this is a different case? That was your bill, okay, all right, because that was a cluster, and now I don't even know how I feel about this bill, because that situation is messing with my brain. It looks wordy.
Someone basically had trumped up criminal charges brought against them in retaliation for them in their course of work, doing one of these welfare investigations, and the person who was the wrongdoer used the commissioner charging process to get someone at work charged with a crime.
Okay.
And so that was the genesis of this. The CAC issue is a totally different issue.
Okay, I was because there was a lot of internal problems there, and so I want to know who are we helping in that situation, because I could almost not figure out guilt in that quagmire myself. So anyways, okay, I'm still a little weird about this bill, but.
Thank you, Mr. Chair. I don't want to belabor this one too much, but can you refresh us as to why this particular cases would benefit by going right to the state's attorney?
Again, and I would argue it's this person and similarly situated people, but people who, in the course of their job, have to make negative decisions against people. They face all sorts of retaliation. So, in the case of these workers, it was them having the target of the investigation make a frivolous criminal allegation against the person, like, oh, you're going to say you found me liable for child abuse? Well, I'm going to go to the commissioner and say you beat me up. So that was this type of case. But again, my argument would be, so there's already a portion of law for teachers, emergency personnel, and law enforcement that says if you're going to make a self-attested criminal allegation against one of those professions, it has to get reviewed before they'll let it go forward. So this is simply adding these other folks. But again, there's lots of people who at work are facing physical or legal threats from the people that are the target of their work. So this is just one in a line of these bills.
Okay.
Okay, sorry for the second bite, but the more I sit here, the more uncomfortable I get. And it really has a lot to do with the current state of DSS. So we're now going to be protecting the people that couldn't tell us how many kids died in our state. I just really don't like it, so I will be no.
Okay.
I think the idea, right, Delegate Moon, is it puts it into the state's attorney's bailiwick, and the state's attorney can decide to go forward with it or not. It puts it in their hands sooner rather than later, so that in these cases of people where you have people who will attempt to take out charges against them as retaliation for some official action they've taken, it gives the state's attorney the ability to look at those things sooner rather than later.
If you actually believe there might be some merit to the underlying allegation in the commissioner charge, this is forcing the state's attorney to investigate it immediately.
And it allows the investigation to start sooner.
Does it skip the commissioner process completely? Or can they still go to the commissioner?
No.
The whole bill is the commissioner has to send it to the state's attorney at the same time that they do whatever they're doing.
Right, so they do whatever they're doing, and then they send it to the state's attorney at the same time. So it's not necessarily cutting anybody out. In fact, the commissioner would still have to set a bond, would still have to do those things anyway. Yeah, and, the state's attorney would get the charges later. Right, that's right. Okay. But even still, it moves it along faster. But Delegate Valentine?
Some of my questions were already answered, but like I'm looking at the statute already, and it already includes educators and like everyone in the school system, as well as the EMS and the firefighters and the police, correctional officers. So this is just one additional. So, okay.
Pardon?
Yeah. I would just say that in relation to Delegate Valentine's comments earlier, is that we have this issue in Baltimore County, and this just allows these folks who are facing these problems to have a little bit more of a backbone to make sure that these are legitimate charges. And I think it's a great idea. In fact, I'm looking forward to seeing what might come out of this in future years.
I just pulled up the testimony. Did you guys look through the testimony from OPD about it? I mean, Their testimony pretty much echoes what I just, my concern, that they've said in there that if they feel like this is protecting people, specifically the caseworkers, who should be held to a higher standard. I don't know how, I mean, if all we're doing is taking the charging documents and moving them faster, how would that, what am I missing? It feels like I must be missing something here, because if they have that concern. Maybe. It's about 3 pages long, so that's a long flaw. I don't know.
Delegate Valentine.
I can give a little bit different perspective on this, having been on the other end of this when working in the state's attorney's office. So as working with citizen complaints or complaints from agencies, if we received the court commissioner would take an application for charges, they would send it to our office if it involved a correctional officer, for example. That case would then be assigned to me. So I would get involved in the investigation itself, take and pull the tapes, all the files, and then determine whether or not it would be applicable to actually file charges. So you actually are doing a more thorough of an investigation, but a summons or a warrant isn't issued right off the bat. So if that helps explain it a little more. It's a screening process.
On the bill is here for a favorable, and seeing no one else's light on, okay. The vice chair.
Yes.
Yes, Valentine.
Yes.
Yes, Crutchfield.
Yes.
Yes, Cardin.
Yes.
Yes, Tomlinson. Yes, Embry. Yes, Pasteur. Yes, Tolles. Yes, Schmidt. Yes, Simmons. Yes, Boucher. Yes, Phillips. Yes, Stinnett. Yes, Congolo. Yes, Erican. No. Taylor. Yes. Simpson. Yes. Grammer. No. Sample Hughes. Yes. Moon. Yes. Conaway. Yes. Kaufman. Yes. Williams. All right, that's House Bill 302. Delegate Simpson has a bill, House Bill 492. And there do not appear to be amendments to 492. There's a motion for a favorable. Is there a second? And there is. All right, are there any questions regarding House Bill 492, which Delegate Simpson, I believe, is a local bill? Okay. You want to say what the bill does?
It just expands, it allows them to use fingerprint-assisted background checks in addition to the background checks that they're doing with the sheriff's office. So some individuals can, be hired sooner and have a quicker background check.
All right. Are there questions regarding the bill? Seeing none, the vice chair?
Yes.
Yes, Valentine?
Yes.
Yes, Crutchfield? Yes, Cardin? Yes, Tomlinson? Yes, Embry? Yes, Pasteur? Yes, Tolles? None. Schmidt? Yes, Simmons? Yes, Boucher? Yes, Phillips? Yes, Stinnett? Yes, Congolo? Yes, Erican? Yes, Taylor? Yes, Simpson? Yes, Grammer? Yes, okay. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? Tolles? Yes. That's House Bill 492. Holding for 579 one more time. And some more about that later. House Bill 610. House Bill 610 is Delegate Taylor's bill. There's a motion for a favorable. Delegate Taylor found an Easter egg. Delegate Taylor found an Easter egg. There was one judge in Prince George's County who would rule that the court made no finding and then terminate the case without a finding, which kind of looks like a dismissal, but doesn't act like a dismissal for the purposes of our expungement laws. So to that end, we're adding those cases, and there are a small number of them in Prince George's County, into the same category as what we've had for the expungements.
Of convictions.
Yes. So it covers So they'll be able to expunge the no finding and case terminated without a finding. So it covers them in the convictions portion. All right. In the end, it allows them to be expunged, and that is the Easter egg that Delegate Taylor found. There's a motion and a second. Are there questions here? This is a very rare form of a verdict, not even really a verdict, I would argue, but Delegate Valentine.
This disposition had to be for the case, correct? Not like a single charge? So like it would have been a.
I guess it could have been for both, but it's either one.
I'm looking about the unital, like can they still expunge if they found a no finding?
Then they have a problem with the
The
unital.
unital.
Yeah, they still, but I don't, that does not appear to be the case here. It was in a limited number of cases, from what I understand.
All right, thank you.
All right, are there questions, other questions, any questions? Seeing none. The Vice Chair,
No, and good job, Delegate Taylor.
did you vote against
I
this
mean,
bill?
yes. Can I do a redo, Mr. Chair?
Let's try this again. The Vice Chair.
Yes.
Oh, okay.
Good job, Delegate Taylor.
Valentine.
Yes.
Yes. Crutchfield. Yes. Cardin. Yes. Tomlinson. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Simmons. Yes. Boucher. Yes. Phillips. Yes. Stinnett. Yes. Congolo. Yes. Congolo. Better. Erican. Okay. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
All right.
Delegate Embry wanted to see if we could put on the record that we don't encourage any of the judges to do this.
Right.
So done. We've done that. Good.
There were no amendments
We
to
have,
610, correct?
there were no amendments to 610. There are amendments, however, to 674. 674 is Delegate Kaufman's bill and so has a questionable sponsor.
Move the amendment.
There's amendments. 933, all right, pay attention to the amendments. 933829.
Move the amendment.
There's a motion for the amendments and a second. The amendments, who would like to describe what the amendments do? This is Delegate Kaufman. Do you want to take a swing at what the amendments do, please?
Yes, I can, and Delegate Williams can help me if not. The first thing that the amendments do are just change some wording. The second thing is that my original bill had a 10-year penalty. The subcommittee, in their wisdom, which I fully support, decided to reduce that penalty to 5, but you're still going to be spending a substantial amount of time in the slammer compared to what it is now, because it used to just be a year. And it also maintains that it is a felony, which is very important because then the state's attorneys don't have the statute of limitations bill. And my bill also said that the sentence should be served consecutively, but the subcommittee changed it to concurrently. Did I get it right, Delegate Williams?
Well, consecutive or concurrent?
Maybe.
Concurrent.
Okay, thanks. Again, my free law degree is getting better. Okay, thank you.
Are there questions? The Vice Chair.
So it's may be consecutive or concurrent, right? Okay, just wanted to make sure I understood.
So it doesn't have to be consecutive, right? It could be either, one or the other.
change too, Mr. Chair, about the crime.
You want to speak about the crime?
Well, yes, Mr. Chair, there were two other amendments as well.
Okay.
Just removing the death of another to just a crime with the intent to conceal a crime. And then we struck out A1, which is the failure to contact emergency medical services. So that's the totality of the amendments.
All right. Delegate Eric.
Okay, so now it's not just about concealing death, it's about concealing any crimes, period?
That's correct.
Wow, and then my other question's for Claire. Do we have a lot of 5-year felonies? Just wondering.
There's a couple gone.
There are some.
Yes.
Okay.
And there are some that are even less than 5 years. We
Okay.
looked at it.
All
looked
right.
at the list.
All right, sounds fine.
Delegate Sample Hughes.
Thank you, Mr. Chair. So my question is on the amendment that removes, I think it removes death and replaces it with homicide. How do,
Homicide with a crime.
say that again, I'm sorry.
With a crime, not homicide. Because homicide is just one type of crime.
Right. So you're saying that's no longer there?
So instead of saying with the death, that was the amendment before this amendment.
Got it. That's the part I messed up. I didn't realize there was an amendment before the amendment, before the amendment.
Yes,
Got
yes.
it. Thank you.
Got it.
Delegate Cardin.
Thank you. So it still deals with dismembering or burying human remains,
That is correct.
right? So if you for some reason got into your possession human remains, let's say that you are a intern in a hospital and you're doing your anatomy and you steal a bone and then you bury that bone. That's fine. That's a crime. You could serve a felony. Huh?
What's your question again?
Theft of a bone. That would open you up to exposure to a felony in 5 years.
If you did what?
If you,
He stole the
Let Delegate Cardin
if you,
ask his question.
if I visited the anatomy lab with my law student nephew and I stole a bone from the anatomy lab and buried it because now I'm scared. Oh my God, I stole a skull, and now I'm scared. I'm going to bury it. Not only I'm on the hook for the theft, but I'm also on the hook for a 5-year felony for concealing it by burying it.
You were just stealing an individual bone, not the skull.
I'm trying to conceal the crime of theft.
That would be correct as I read this bill. Yes.
Okay.
Would ask you to exert self-control whenever you're at the anatomy lab in front of the cadavers. Delegate Phillips, God willing, is not going in the same direction, but let's find out.
No.
Delegate Phillips, here we go.
No, I actually don't think I don't think this would apply because the language is about concealing the death. That death at the cadaver lab has already occurred.
I'm sorry, say that again. So you're talking about it being changing it to concealing the crime as opposed to concealing the death?
I may be wrong. It just seems to me that the death has already occurred.
Yeah.
Yes. Yes.
And so that what he just described is no longer it's not relevant at that point.
No, it is.
It is?
I'm sorry, Vice Chair's over here. Delegate Williams.
So we removed the word death and replaced it with a crime. So
But the crime of death.
no, it has nothing to do with death anymore. The full sentence reads, a person may not, with the intent to conceal a crime, knowingly and willfully dismember, destroy, remove, which John is removing the bone, or otherwise obliterate by any means any portion of human remains, or bury or otherwise dispose of a dead body. So, yeah, he would, but, I mean, he would be charged probably with theft as well, and then the state's attorney could determine, right. And the charges could be, concurrent. I mean, if he got sentenced, it could be concurrent.
Okay.
Well, it could be consecutive or concurrent. So if he got the theft and he got this penalty, he could conceivably, depending on the value of the bone,
I was thinking that.
which I would assume would be
Less than 15,
Less than $1,500,
so it's not,
less than $100, could be a 30-day penalty and then a 5-year penalty on top of it. Depends, we're getting a little far afield here, but let's take a couple more questions and we'll go from there. Delegate Conaway and then sample use.
Just in support of my colleague, there are currently questions in the metaphysical community and other communities like Django about skull structures and identification and so forth and so on. So it is a serious issue. Thank you.
Thank you, Mr. Chair. So would this mean that the very first intent of the bill, which was talking about failing to contact emergency medical services and law enforcement, that means that that's out of the bill?
that's out of the bill.
I thought that was the whole purpose for us to make sure that,
Well, the way, yeah. So the way the bill was originally written, it was phrased in a way where it was an or. So the worry amongst the subcommittee was that if you fail to contact emergency services but don't do any of the other things, that you could be on the hook for a felony. And so that's why we took it out, because I don't even know. What if you're so grief-stricken, you found your grandmother laying dead, and you're so overcome with grief that you just sit there and just decide not to call the ambulance for like a good 12 hours? In theory, you could have been convicted of a felony under this bill, the way it was originally written, which is why that portion was struck out. Oh, and there's also an existing misdemeanor for failure to report the death of a child.
right, I saw that in the expungement stuff. Okay, so that changes Delegate Kaufman's original intent.
Well, I think the intent is still there, because the intent was to get after individuals who are literally dismembering bodies and trying to destroy bodies to conceal the fact that they killed someone or hurt them in a way that resulted in their death, and then tried to hide the fact that they killed them. I think it still gets to that.
I think that you could have a situation where if somebody was accused of a sexual assault, this would apply if they tried to dismember the body in order to prevent the rape kit from being done or something along those lines. If it was a serious assault that resulted in death, yeah, you could see. That seems to me, that is probably the more common usage of this bill.
Okay.
Delegate Eric.
Thank you.
Sorry, I got a couple of questions. Okay, a dentist I had a long time ago had a human skull on his desk, and I remember asking, I said, that's not real, isn't it? He said, no, actually it is real. I didn't ask the provenance of that, but would he potentially be in trouble for having a real human skull?
Because it wasn't with the intent to conceal a crime.
Okay, and what if you only have the hair?
If he's not trying to conceal a crime?
Not him, he didn't have the hair.
Oh, he didn't have the hair.
No,
Dennis
this is a
didn't have
different
the-
scenario. What if someone took not a body part, but just was in possession of human hair from a crime victim?
Are they concealing a crime?
Maybe. So that would count?
Yes,
Okay.
it would count.
Okay.
Yeah, because.
Because people do that sometimes. They'll
to try to hide
chuck the whole
DNA.
body, they'll keep only the hair, we'll find only the hair at the residence, and there was for sure a crime that happened, so.
All right, Delegate Taylor.
Thank you, Mr. Chair. I hate to beat a dead body. I'm sorry. I wonder if Delegate Cardin's example would not fit here, because bury is not a part of A2, but it is a part of what is now, A1, which is now a part of A2. A2 says bury or otherwise dispose of a dead body, not dead body parts. Do you think we should put parts in there so it's clearer, or that it's more specific?
Subcommittee Chair. Delegate Wood.
I mean, it's an or, so. Yeah.
But it doesn't say bury in one. It only says dismember, destroy, remove, or obliterate. It doesn't mention burying.
Right, so it could be a felony if you just did any of those things without the burial.
Correct. But if you just buried an arm that you stole from the museum, where does
Oh,
that fit?
I see what you're saying.
She wants to make sure he's in trouble.
With the intent
Or
to
not,
conceal a
or not. I
crime.
mean, if it's, all I wanted to bring up was that maybe his
Stop
example
stealing
did not
together
fit
from a
here,
crime.
and then it would be okay.
I mean, we could just do like.
One moment,
stick, bury,
please.
and knowingly and willfully dismember, destroy, remove, bury, or otherwise obliterate by any means any portion of human remains.
Oh, yeah, we could do that.
Because then knowingly and willfully.
I mean, if you buried a finger.
Yeah, which we would want that to apply to the bury of the remains.
Right.
Okay, we may have an amendment coming forth to address your concern.
All right, we're going to hold it. We'll hold it. We'll come back to this. Let's just hold it till tomorrow and we'll fix it. All right, House Bill 1123, we're going to medical and elder parole. There is another amendment, as I understand it, going to the question from Delegate Valentine last night as to who makes the decision. And so after having conversations with the Health and Government Operations Chair and with people on that committee, reviewing the law, the licensed medical practitioner is not defined.
We're back to.
We're at 1123 with, this is medical parole.
We're skipping.
We're skipping, we're going to medical parole because there's some other parole bills, but this one was left over and I wanted to deal with this one. So sue me. Okay, so 1123, so the idea here is that it changes the, in the bill where it says licensed medical professional to licensed physician. There's a motion for a favorable and a second on the amendment. Are there questions regarding this change in the bill that would make it clearer, I think, and more specific as to who we're looking for? We're looking for a doctor. Okay. Delegate Kaufman, your light's on.
Oh, I was just gonna, yeah, I wasn't called on in the last bill. I was just gonna answer Delegate Sample Hughes's question and say that I'm fine with the committee amendments. I think it still does my intent. So.
Okay. All right, that was on the last bill. Now we're on this bill. So anyone with questions about the licensed physician language? All right, all in favor of that amendment, please raise your hands. Anybody opposed? All right, that amendment is adopted. Now we're on the bill as amended.
Move the bill as amended.
And there's a favorable and a second. All right. Now we're on the bill. Discussion on the bill. Anyone with questions or further discussion on the bill? All right. We will take a vote. The vice chair?
Yes.
Yes. Valentine?
No.
No. Crutchfield?
Yes.
Yes. Carden?
Yes, to explain, I just kind of talked to the MSAA about 60 versus 65.
I understand.
So, and an ad, please.
Crutchfield adds. Tomlinson? All right. Embry? Yes, and an ad. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes, and an ad. Boucher? No. Phillips? Yes, and an ad. Stinnett? Yes, and an ad. Congolo? No. Arakan? No. Taylor? Yes, and an ad. Simpson? Yes, and an ad. Grammer? No. Sample Hughes? Yes. Moon? Yes. Conaway? Yes, and an ad. Kaufman? Yes. Williams?
And an ad.
Kaufman is yes and an ad. Williams?
Yes, and an ad.
Yes, and an ad. The chair votes aye. The favorable motion with amendment is adopted on 1123. Now, we've got that part done. And, okay, so much to choose from. Let's start to talk with House Bill 1156. 1156, actually, wait a minute, let's go to an oldie but a goodie. House Bill 1198, the Women's Pre-Release Center, everybody. There are no amendments. There's a motion for a favorable and a second. Oh, in the long story of the Women's Pre-Release Center, someday it will get built, someday perhaps.
That's right.
Yeah, well, we are passing this bill again. And passing it clean. All right. Does anyone have any questions about House Bill 1198? Sorry, Delegate Williams.
Not really a question.
Okay.
Not really a question, Mr. Chair, but I'm really happy that we are able to move this bill. I really hope that the Department of Corrections will see this bill in a positive light, in the sense that we are all trying to work collectively to do the right thing for women who are incarcerated, to reduce recidivism, so that we can assist individuals to restart their lives and be productive members of society. That is the whole purpose of this bill, and that we want to work collaboratively with them to make sure that the facility that is built is the right facility, the proper facility, and will provide the services that should have always been provided all of these years. That's all I want to say.
Schmidt.
Thank you, Mr. Chair. Mine was, I know this has been a project that's been for several years, I believe, like. Several years.
X million years.
I know there was some financial statements in there about money that's already been spent to date, as well as money that's coming. And can you just clarify how that all kind of works out?
Delegate Crutchfield.
Yes, I'd be happy to do that. So in 2021, when this was passed, there was no money put in the budget regarding this, or at least let's put it like this: Departments of Corrections did not ask for money. Then in 2023, they did ask for money, and it was about $2 million. And since that time, it's been about $9 million total. However, they have not used the money towards any of the design, build, or anything to get the structure in place. So money is sitting there waiting for them to actually do this. They have located a site, as I've mentioned in my testimony earlier, which is not a site that we really want this to be built on. However, again, they have not really used the money. So the money is appropriated, the money is there. In fact, I believe the governor even has put in additional money in this new budget. However, it has not been used. So again, the money is available to do, at least to get started on this, okay?
Delegate Valentine.
That was my point, to get started, but not for the entire project.
Yes, that is correct.
Thank you, Chair. Do we know what additional money? And I have some notes that say that it was 90 million or 93 million. Was that correct?
So originally, that was, excuse me, Mr. Chair, is it okay? Sorry, thank you. So originally, that was indicated. However, we have noted since that time, it does not take $90 million to build this facility. In fact, there is a facility that is in the works in Baltimore that has been quoted as being a Baltimore treatment center with plans to build that at $1 billion, okay? So there is money that is being allocated certain places that could possibly be transferred back to this, because we're not sure that Baltimore Treatment Center will actually happen. But yes, that is correct. Originally it was 90 million, but it's a much lower number now.
Do you have an idea? Do we have an idea of what that might look like?
No, not yet, because it depends on, again, the location. Right now, they're estimating probably about 85 million, but again, that's based on the location they've selected right now, which means that it will be multiple stories. It will not be a one-story facility. However, there is still the old Baltimore Treatment Center, I'm sorry, the old Baltimore, the original location where this was in Baltimore that's still vacant and could possibly be used and renovated. So there's lots of opportunity here to actually spend less money and actually locate or build on a smaller lot or even a larger lot. So there's a lot of opportunity.
Okay, I appreciate that. I support the bill, and it's how we're going to pay. How are we going to pay for it?
Well, thank you.
Right. You're welcome. Thank you. Thank you, Chair.
Any questions? Any further questions?
Delegate Tomlinson.
What happened? Oh, I'm sorry. Delegate Tomlinson, yes.
Thank you, Mr. Chairman. So a
couple things. So obviously, this is a building that will be used by public safety, and I think your testimony, I think, is accurate that, well, no, I know that it's accurate that, yeah, Department of General Services will, I mean, they're the ones who have put out the RFP. They're the ones who purchased the land. They're the ones who did the design, all that. So I'm just making that clear because I have not been involved at all in this procurement. This was handled by a completely different agency, Department of General Services. I mean, I just checked on eMaryland Marketplace. It was advertised in February. It's going to be, proposals are coming in, I think, on March 17th, so about a week out. Obviously, you want to see a pre-release center built, and you have a specific idea of what it should look like. But essentially, this is going to, I mean, if this bill passes, DGS is going to have to cancel that procurement and all the work that went into it. And as somebody who works in procurement, I understand how much work goes into that, especially at this. I mean, the fact that proposals are coming in a week means that they're on the tail end of what has been a very long process. So this is starting everything all over again. And I think the informational letter from the agency, I mean, kind of hits all the marks that these dates that are in the bill are not going to be realistic as far as being able to get this project done.
Thank you, Mr. Chair. So a couple of things. One is that you mentioned February of this year, right? That was the date when the rec went out, right?
Yes.
So again, this bill, the original bill was passed in 2021 with a deadline of 2023. That did not happen, okay?
It's not good.
As of last summer is when we got more information on the location where they wanted to propose this be built, all right? So we're talking about what, almost 8 months now? And just now, because the bill is in place, that they have now decided to go ahead and get an RFQ out. So that's part of the issue, okay? So I'm glad to hear that the bill is doing something because it's pushing people to do something.
And inspire DGS to start moving.
Right, exactly. And the Department of Corrections, right? They're the ones pushing now to say we need to get this bill. But the horrible part of all of this is that it's not at a location that is viable for success for the women. And that is the problem. Okay, they selected someplace without many stakeholders' involvement, and it's actually a parking lot that they currently own that is adjacent to the Baltimore Detention Center. And so that is a real huge problem with a small space, et cetera. Whereas previous opportunities included a school in Baltimore City. Again, like I said, the old facility where originally the women were in a pre-release unit is still available. In fact, in 2009 is when that facility was closed with the whole notion that they would rebuild a bigger location, but that never happened. So, you know, there's a lot of moving pieces. I know there's a lot, you know, as you said, being in procurement, I understand there's a lot going on, and you're right, people work hard to make things happen, but they should make things happen for the right reasons and in the right places.
Yeah, it just, I mean, yeah, if the goal, and obviously the goal here is to build a pre-release facility for women, it's, and I agree with you, it should have
been done.
Should have been done. You know, I've experienced my own troubles with DGS sometimes not moving quick enough. I can back you on that, but it is gonna drag out the process.
Yeah, but it shouldn't
longer.
do it in a harmful way. It shouldn't be that much more, because believe you me, there's a listing of properties that are available. They're just selecting the one that they own, even though it's a parking lot. That is the reason why it is being selected.
So you do think it's not going to be that difficult to? I'm looking at your testimony to kind of check all the boxes that you've.
Yes, I believe there's still facilities there in Baltimore City that meet the original guidelines, which were a few zip codes that we wanted this to be built in because it has to do with where returning women are going. And so that has already been done, but yet, again, that selection criteria, that process is all available.
Okay. And with the dates that are established in the bill, you think that those are going to be achievable?
Well, just like the previous dates, the previous dates were put in there and they did not adhere to those. However, the real big issue here is to get them moving in some direction and to make it really, a viable situation. And if the dates have to slide a little bit because of that, that's fine. I think people will be better for it if they do slide and we get the right property so we can build the right kind of facility, because that's really what this is all about, making sure the right facility is built for the women, because they deserve it. They deserve to be successful coming out. They deserve to have the gender responsive kind of services. They deserve to be able to bond with their children and to just be successful. This will reduce recidivism. This will do a lot for women. And right now, there's really no pre-release kind of services there. They say they are, but it's for a very selected few. And it should be for all the women that are in pre-release, classified as pre-release.
Gotcha. All right, thank you.
You're welcome.
Any further questions? Any further questions? Seeing none. The Vice Chair?
Yes.
Yes. Valentine? No. No. Crutchfield?
Yes.
Yes. Cardin? Yes. Yes. Tomlinson? No. Embry? Yes. Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Yes. Simmons? Yes. Yes. Boucher? Yes. Yes. Phillips? Yes. Yes. Stinnett? Yes. Yes. Congolo? No. Arakan? No. Taylor? Yes. Yes. Simpson? Yes. Yes. Grammer? No. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams?
Yes.
All right. Motion is, the chair votes yes, because every year for 7 years, we have passed something on this very issue. It's getting a little old. And I very much hope that there could be real progress very shortly. And I know there's been some progress made, but I certainly hope that more progress will be made quickly on the issue. With that, I will stop bloviating and now go to Delegate Phillips, House Bill 1156, which does not appear to have any amendments.
Move the bill.
There's a motion for a favorable. Is there a second? Second. Delegate Phillips, do you want to talk to the committee about what the bill does?
The bill really does two things. One is it alters, well, three things. It alters the number of commissioners to move it to at least 15, no more than 20. It removes the hearing examiners. It, in essence, pays for the adding of commissioners because the examiner's compensation is approximately $99,000 a year. The commissioners' salaries are about $117,000 a year. So we cover that. It also changes the way commissioners are appointed. And those commissioners would go through a process to be selected by something equivalent to, well, similar to a judicial nominating commission. There'd be a group of individuals. They would get recommended. They would be recommended to the governor, and the governor would select from those recommendations. Those individuals would be more transparent. The process would be more transparent and more accountable. That's what this does.
Second already, so we're on the bill. Delegate Valentine.
Thank you, Mr. Chair. And I just wanted to confirm that the information in the fiscal note's correct with the new PIN numbers, the 21 new positions at a cost of a little over $1 million more a year. Is that accurate?
I actually think that maybe a little bit overblown. I think that was suggesting that they would take significantly more staff, especially if they have hearing examiners. That's how it works, but that's what they
Okay.
The idea is that you're eliminating the hearing examiners and you're effectively making them members of the parole commission. So we're putting them in the jobs that they're effectively doing right now, as I understand it. So I don't know that the fiscal impact is as significant. Delegate Valentine.
But they're going to add additional to what's already there as at a higher salary, correct?
Yes, but I think that the question, and I think the parole commission is comfortable with the bill. I think the question is how they go about it, and I'm hopeful that they'll go about it in the least, in a fiscally responsible way. Are there other questions? Seeing none, the vice chair?
Yes.
Yes. Valentine?
No.
No. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson?
No.
No. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons? Yes. Boucher? No. Phillips? Yes. Stinnett? Yes. Congolo? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Sample Hughes? No. Moon? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. Okay. That's House Bill 1156. Delegate Embry does have amendments, including one that came a little bit recently. So I think, well, let's do this. We're going to take up House Bill 238. And House Bill 238, Delegate Cardin, this is your bill. Is anyone in the committee offering an amendment? Seeing none, I'll take a motion. There's a motion for a favorable and a second. Are there any questions regarding House Bill 238? Seeing none, the vice chair, oh wait, I'm sorry, Delegate Taylor?
Just to be, please tell us what it does again.
Okay, this is, Delegate Cardin, do you want to talk about what the bill does? It's the year and a day rule.
It's the year and day rule bill that we've heard now 3 or 4 years in a row. Currently, the law requires a complaint involved in the public to be initiated as soon as it comes to the attention of the appropriate law enforcement official. 238 requires internal complaints not involving the public to be initiated as soon as it comes to the attention of the appropriate law enforcement official. And then they have a year and a day to make a determination as to what to do.
Under police reform, internal complaints are different than complaints that are brought by people from the outside. So these are viewed as technical, sometimes technical. You didn't come to work on time, you didn't pull up your socks. That's the idea. I mean, I don't mean to minimize it. There are some of these that are significant and they are serious, but they need to, part of the challenge is they need to move forward and then move through the process in the year and a day period. All right, Delegate Pasteur.
Thank you. Mr. Chair, is this for all police staff, police officers, administrative staff, other folks?
It would be for anyone within the police. I think it's for the sworn officers, correct? It's not for staff. Staff is different than the sworn officers.
Sworn officers.
It's law enforcement officer as opposed to the person who's staffing the evidence locker, unless they are a law enforcement officer.
That is correct.
Okay, thank you. Any further questions? Seeing none. The vice chair?
Yes.
Yes. Valentine?
Yes.
Yes. Crutchfield?
Yes.
Yes. Cardin?
Yes.
Yes. Tomlinson? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons? Yes. Boucher? Yes. Phillips? Yes. Stinnett? Yes. Congolo? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Sample Hughes? Yes. Moon? Yes. Conaway? Yes. Kaufman?
No, may I explain my vote?
Yes.
I agree, despite my high regard for the sponsors, I agree with the public defender's position that this is highly problematic, given that litigation often takes more than 1 year and 1 day. So I think in the end, it will close and result in more investigations being closed due to the time limit. So I think it will close the doors for justice for too many people, and that's why I'm a no.
Williams?
Yes.
Yes. All right, favorable on 238. We're going to talk about 1147 now. There are amendments, and there are several amendments. Delegate Embry, would you like to talk about the amendments that are there? And some of these amendments are relatively fresh, and you just got them. If people feel comfortable with them, we can move them. If people don't feel comfortable with them, we'll see where we are. But Delegate Embry, if you would, please, before I move the amendments, I'm going to have her go through them conceptually. Delegate
And
Embry.
there is, Chair, a tweak to one of the portions of it that, what I texted you about, the one addition to the amendment, so, which could be a separate amendment, but I just wanted to flag that. Okay. So briefly, this bill adds sort of due process to the parole process, and most importantly, requires that a person actually have a scheduled parole hearing if they're denied, which currently most do, but not all. There's a segment of people who are in this category called refused, where they're not technically denied, but they are sort of in limbo. So this would require that everybody who's eligible for parole, if they're denied, they get a date certain. I'm sorry. Yeah. And so I've been trying to work with the Department of Public Safety, the reform advocates, and also MCASA with the concerns they raised in their testimony. And so the amendments attempt to do that. One concern raised by DPSCS was the cost of transcription. So instead of transcribing, we will just provide an audio recording to the inmate and their attorney, and that will have victim information, personal information redacted. And that does not eliminate the cost, but reduces the cost to the agency. Additionally, we will add clarification that victim impact statement, whether it's made at sentencing or at a previous parole hearing, will be considered at every subsequent hearing. That is in the law to some extent, but we're just clarifying that. Also adding that a stay-away order will be provided in cases involving a victim unless the victim requests otherwise. That is something the agency can do. And then the tricky part where we're not entirely resolved is the length of time. So the bill as written originally says that a person who's denied parole will receive a date within 2 years, no later than 2 years. And that was of concern both to the agency for a number of reasons, including cost, and also MCASA because of the impact on victims. So what the amendment does is says for sentences of 10 years or less, it is 2 years. For sentences of 10 to 20 years, it will be not later than 3 years. And for sentences of 20 years or more, after their first hearing, when they become eligible, the next date will be within 3 years, but will be within 5 years after that. But in order to pare that down, the latest compromise, which hopefully is the final one, would say the 5 years would only apply in cases involving crimes against individuals. So if a person is convicted of drug crime or theft, or excuse me, drug crime or non-victim crime, they would receive a sentence within 3 years, no later than 3 years. Now, the no later means the person can receive a sentence at any point, but it's trying to accomplish the goal of them receiving a date certain and not being in limbo. So that is my explanation of the amendments.
So now with all of that having been said, can you talk about what the bill now looks like as amended under those amendments?
So it does a number of things. One is, as the bill originally is written, it provides due process throughout the process. So instead of a person having to request to review the file or the things that the parole hearing examiner will rely on, they get it automatically with appropriate redactions if there's confidential information. They will automatically receive a recording of their hearing afterwards. They don't have to request it. They will get a date certain if they're denied, instead of being in limbo. Those are the most critical, but now, and also the few more protections for victims are added in, this sort of automatic stay away unless the victim requires otherwise, and a little bit more clarification that a victim impact statement will be considered.
Okay, so that was a lot, and there's a lot here. And it goes to issues, as I see it, that the Parole Commission has some changes the Parole Commission has needed to make for some time. And so that this, and I would argue Delegate Phillips' bill from just a moment ago, begin to address some of those underlying issues that we've needed to deal with that we haven't for years and years. So with that, are all of your amendments ready, or there's one that is not quite ready?
And I forgot to add, I'm sorry, it also provides a shorter turnaround for, I'm sorry, that is the final amendment. So in the bill, it was that they would receive their decisions within 7 days with all of the reasons articulated. The compromise is 14 days. So it's from 30 to 14, and adding the reasons have to be explicated.
Do people have questions for Delegate Embry right now, knowing that we will move on this bill at the next bill hearing? Delegate Schmidt.
Thank you, Chair. I do have a couple questions here. I have some notes here that it still adds 12 new positions with a $600,000 fiscal note, or is that?
I believe we're now at 3 positions by cutting out the transcription.
Okay, and what's
Although that is not a definite number, so I want to caveat that. I'm sorry, I believe, we were at a number lower than that because a portion of that was the cost of hiring people to transcribe.
Somewhere between 3 and 12.
Correct.
Thank you.
Other questions for right now? All right, we're going to try and take care of the last amendment that Delegate Embry is working on. We'll get an interlineated copy and get it sent out for everybody. I want people to see the interlineated, and we can do that. So for right now, we are done. However, tomorrow I anticipate 2 sessions, one in the morning, one in the afternoon. Anticipate double sessions the rest of the way. I anticipate we will have a voting session in between the first and second sessions. There may be, I don't know, that I hear rumor of a caucus meeting somewhere in between the first and second, but I don't know. Delegate Kramer.
Thank you, Mr. Chair. Are we coming in Saturday?
Yes. Without question, coming in Saturday.
Just get letter 25.
One moment, please. 11:25? Yes, we're not doing 11:25 yet today. Okay, we are definitely coming in on Saturday. And do any of the subcommittees need to have any further meetings at this point?
Meeting at 9 a.m. tomorrow.
All right, so Delegate Williams, subcommittee meeting at 9.
We got to get stuff out to get to on the voting list for tomorrow. I understand, but as you heard the chair say, we're going to have other caucus stuff in the middle of the day. I don't think there's any time in the middle of the day.
Charlotte, do you have?
I mean, I don't think the meeting will take long. It's about the same thing we talked about.
All right, we can do it after we can do it, well, I don't know if we can do it immediately after the first session, but we will do it immediately before, we will do it immediately. You can have your subcommittee meeting immediately before our voting session, which will happen in between the first and second sessions tomorrow, to allow for that meeting and to go from there. So that's the best that we can do. All right? Thank you all very much.